Thanks so much, Jeff, for that presentation. So as he mentioned, now we're going to break out into a panel discussion, but in doing so, we're going to introduce two new people to the stage. The first is going to be Jim Marquith. Jim is the founder and managing partner of Marquith Law, a technology law firm with offices in Seattle, Annapolis, and DC. He started his career as a litigator and a transactional attorney in Silicon Valley and went on to hold the executive and senior in-house legal positions with Microsoft, Allscripts Healthcare, GE Healthcare IT, and Adobe Systems. Mr. Marquith's clients range from startups to large technology leaders, representing a range of industries and offerings, including healthcare IT, web services, computer software, data analytics, standards development organizations, and healthcare payers and providers. We're also going to welcome Michigan's own Nate Steed. Nate counsels organizations in technology and intellectual property law, health law, and privacy and information and security law. His specialty involves the acquisition and use of software and hardware and the Internet of Things. In addition to his technology practice, Nate frequently speaks on maintaining compliance with state and federal privacy and information security laws. So I'll welcome you both to stage now.
I feel like that this is two debate teams here on either side of the podium, but we'll try to keep this collegial. So Nate and Jim, I think you heard a lot from John and myself on what's included in TEFCA, what's included in the ONC and CMS rules. I don't know if you want to run through some of your thoughts and impressions on kind of all these different vehicles that are currently open for comment.
Sure. Hello, and thank you for inviting me here today, Jim Marquith. I'll first say that I'm a fan of TEFCA. A little bit of background that you didn't hear about me is that I'm also the general counsel for the Commonwealth Health Alliance, which is a consortium, industry consortium focused on nationwide interoperability around electronic health records. And we have about 80 members now, including about 70% of the health of the electronic health records vendors, Cerner, Allscripts, many of the big vendors and providers and payers, hopefully too. So I've been seeing some nationwide efforts around interoperability, and while we've been making great strides, the Commonwealth Health Alliance has, there's still challenges, and I agree that one of the biggest challenges is information blocking. There are lots of vendors out there that have experienced information blocking from other vendors when trying to share healthcare information, and it's really rooted in the biggest problem is existing contracts between industry players in the healthcare system. So you have an electronic health records vendor, and one of their clients is a provider, say a big hospital corporation. There's very strict confidentiality and other contract terms that would prevent anyone from sharing a PHI, for example, with another party without permission or without, and certainly without compliance with HIPAA. So a nationwide, especially this common agreement around sharing data that TEFCA would provide, I think is really crucial to opening up data and allowing for nationwide sharing of information properly done to allow, in particular, patients to have access to their own information. So I think TEFCA is the right direction, in my opinion, but I think there's a lot of work to do, but it's at least a good catalyst to make people actually come and actually go that last. We've come many, many miles towards interoperability in lots of industry efforts, but TEFCA is going to help us go the last mile, and I think it's extremely important. Glad to see it happening.
Yeah, I'm with Jim in sharing the optimism for TEFCA. I think having all of these proposed rules on the burner at the same time presents some opportunities and the ability to take a more holistic approach to the way we do this in the United States. So I think that's good. Obviously, the flip side is that it's a lot to digest and try to synthesize at the same time. But I'm with Jim in sharing the optimism for TEFCA and what it can potentially provide for us on a national level. We can talk about some of the nuances and details of that as we get into the discussion, but just very similar comments to Jim to start out with.
So I think John had a great slide that ran through the changes between TEFCA Draft 1 and TEFCA Draft 2. And I compliment ONC for the work that they did to listen to the abundance of comments that they received on the first draft of TEFCA and the changes that they made in the second draft. I think when HIMS commented on the original draft of TEFCA, one of the things that we really tried to point out was the work that was underway, and that alludes to the slide I think that I presented around the different interoperability efforts that are underway. Perhaps those efforts are siloed, but there is a lot of exchange that's happening. There are a lot of business models that have kind of sprung up around exchanging information and trying to make sure that a TEFCA would harness and try to capitalize on some of the work that was already happening across the market, across the industry. So I don't know if you all have any sort of more thoughts around changes between TEFCA 1 and TEFCA 2 and kind of the directionally where we're headed with that.
Yeah, I mean, I was certainly happy to see the inclusion of push notifications in TEFCA 2. I think that was probably one of the biggest comments from version 1. And you can see how it kind of dovetails with the ONC proposed rule for ADT requirements, which kind of as a necessity is a push notice out. So I thought that was one of the best changes from version 1 to version 2, in addition to the more time to get compliant, because while there are a lot of efforts underway, I think the version 2, some of the requirements there are going to require a heavy lift on existing documents and contractual requirements that are already in place among various participants, so the added time is always nice.
I agree. Also, I think the addition of the minimum terms and conditions in version 2 is also very helpful. One of the things, like Nate said, one of the things that us lawyers at least are going to have to do is put new contracts in place. And then we need time to draft that, socialize it with our stakeholders, and then figure out how to way to roll all those contracts out and replace existing contracts. That takes some time. So for all the stakeholders, whether they're participants, users, a QHIN, each one of those parties need to review, digest, accept new contracts, maybe put them in place. So going from 12 months to 18 months and getting those minimum terms out there is a good place to start. We can start thinking about it, how we're going to implement it. So I think that's a very important addition to this new version.
So John, obviously, I think one of the big themes running across all the rules, I think we both spoke about, was about patient access. So do you want to talk a little bit more about some of the patient access provisions? And then Jim and Nate, I'll definitely would be interested in getting your feedback and your reflections on patient access, how that is important as we move forward with all of these initiatives.
Yeah, I think that's a really important point to focus on, because TEFCA is about helping patients, improving patient access. And so the policies that we have proposed here and really spent a lot of time working on trying to design them so that they are able to encourage and support more patient access to their data. So as I was talking through in the presentation, the goal of access is that you can have the data follow you where and when it's needed, and you can get access to it on your smartphone. So to do that, we have to really think through those challenges associated with what are the mechanisms that patients use to get their data. And that includes things like apps and others that are not covered by HIPAA. So what we spent a lot of time focusing in on was how do we make sure that those entities that avail themselves of the data that's on the network also have to meet the bar of privacy and security that would ensure that the network is still trustworthy and those apps are doing the right things, et cetera. So all of those privacy and security protections that we've built in are going to be then imposed upon those apps. I want to mention a couple specifics of what we would require of non-HIPAA entities. So first of all, if you are a non-HIPAA entity and you're connecting into the network for individual access services, you have to respond to requests for individual access service as well from other places on the network. Now, it's important to note, if you are only providing individual access services as an app, then you do not need to respond to other exchange purposes. As a non-HIPAA entity connected into the network, you have to also provide a summary of information disclosures. You have to have a written privacy notice. You have to abide by breach notifications. So these are really important bar that's been put on those apps, and we think that's important in order to ensure the trust of the network.
Thanks, John.
I do want to add just kind of one thing, pick up on what John said. I think one of the important aspects of TEFCA is the imposition of some HIPAA requirements on non-covered entities and non-business associates. I think that's a real nice feature of TEFCA, in that when we first started doing this 10 years ago, we kind of had a more narrow view, like, all right, the information is going to go from a covered entity to another covered entity. But as technology has expanded and use cases and the thinking has expanded, we started to loop in non-HIPAA entities into the transfer of information, so that you have these app developers or you have schools who might want to have access to this information who would not otherwise have been covered by HIPAA, now have to meet some of the HIPAA requirements. And I think that goes a long way toward protecting that information and also getting everybody on the same page as far as compliance. Because frankly, even if you're not subject to HIPAA, if you're touching health information of some sort, it's usually a pretty good idea to comply with the HIPAA terms anyway as the standard of care for protection of that data. And now this kind of goes that step further and embodies it in the agreement and allows us to roll that in through the contracts.
Yeah, I think that emphasis on individuals' access to their health care information is extremely important. And also the ability for an individual to request that certain information in their health record is not shared. But from a technical perspective, there's going to be great challenges there. For example, right now, if you think of, you have an electronic health records vendor working with a provider, they've got contracts between them that say you can't share it except for providing these services. You can't share the provider's data, which is the patient's data. And now you're going to connect that electronic health records vendor is going to have APIs open up to, let's say, individuals and healthcare apps, like health apps on your Apple Watch, et cetera. And how would that, and then electronic health records, by the way, often are exchanged in their entirety in one mass file. So when that individual now can say, hey, I just want part of that information suppressed or not shared, that's going to have to be worked out. That's a technical challenge. It's also a contractual challenge, because now electronic health records vendors don't have the ability or the right to share the data. So from a contract perspective, it has to be worked out, and also from a technical perspective. How do you parse an electronic health record that usually goes all in one piece? It's going to be difficult, but so that's going to be a challenge. I don't know if 18 months is enough to work that out, but we'll see.
I would like to add, too, that beyond even the technical side of it is I don't know what the term is, the socializing the side of it. So both for individuals where we I think are becoming more and more accustomed to having access or expecting access to our data, but also within the organizations themselves, that they know that they can technically do this. And I have a quick story. My wife had an MRI on her knee about 2 months ago. I live in Grand Rapids, so she went to a hospital in Grand Rapids, got the MRI, and wanted to get a second opinion. And she went to the doctor's office for the second opinion, and they said, oh, you're going to have to bring us a CD of the MRI results so we can have access to the images. And I thought, that's insane. I know you two entities are connected. I know because I worked on the contracts connecting you two, but the people in the office didn't know that this was feasible. And it just blew my mind that this was the way that they had to do it, that they thought that they had to do it when they actually didn't. And so this interconnectivity piece of it really has a few kind of individual challenges beyond the technical and legal side of it.
Yeah, can I just jump in? I want to build on something that Jim was saying about the challenges of security labeling. We recognize that for sure. This has come up many times. What are the limitations of, can you fully block out certain parts of the record if they are labeled as sensitive? And so we actually have a request for comment in the TEFCA specifically on this, and really want to get folks' feedback on that, whether it's policy considerations or technical issues associated with that. At this point, though, what we've proposed in TEFCA is to have a meaningful choice provision that is a blanket, completely opt out of the network or not. So that's the first step. That doesn't accomplish, though, the goals that we've heard from patients, that they want to be able to segment out particular parts of the record or not. And yeah, legal, technical challenge. We want to learn and figure out how to do this right.
Yeah, and I think one of the important points is that everyone needs to emphasize has to do with this provision included in TEFCA related to the individual access services. And I think what has been really conveyed to the entire community is that patients do have the right through TEFCA to roll up all of their health information, to make a request through a QHIN, to and do a broadcast query out to the entire healthcare ecosystem for all of their information. And the patient would control that information. The patient would have ownership of that information, and they, again, could share it with whomever they like as a part of their healthcare process. And I think the important provision of that has to do with whether how a provider would or would not have to be involved. So I don't know if Jim or Nate, if you want to talk a little bit about how information should or should not be tailored to as a part of this kind of individual access service sharing, and whether that is a job of physicians, or should patients have the right for to make a request, get their own information, and use it however they like.
It's a really good question. Right now, the standard is that the consent, it's all about consent, right? You can use a patient's data if you have consent from the patient to use it. So somebody's getting that consent. Think of your consent form you fill out when you go to the provider. They always give you a consent form, even though you filled one out 5 times before. So that's typical consent. It takes place right there at the reception at the doctor's office. And that goes to also, there's a process set up by the electronic healthcare records vendor, the provider, the patient, whereby consent is achieved, and that gives the provider, for example, permission to share data with other providers or people in the healthcare industry. So what happens now when you give the patient the right to access healthcare records through their Apple Watch? Where's the consent? I suppose it could be in the terms and conditions in your Apple Watch or that app, right? But the person that holds the data, how do they know that the consent was given by the patient? So that's a problem. It's not information. It's an information blocking problem, because the person holding the data has a right not to release it to somebody. They have a third party in between asking for the data to be given to the individual. How do you know it's been consented to? I think the consent is going to be a big challenge, because this new model is quite different from our old model.
I think also general economic principles, as you remove the barriers to something, make it more easy, the consumption is going to increase. So as the ability to request information for individuals becomes easier, you're going to see more requests, and that has potential HIPAA implications as well if you're a healthcare provider in responding to those requests for access. I bet most healthcare providers right now only get a handful of individuals exercising their individual rights under HIPAA in any given year. Most people just don't even know that they have that right, but as you have the technology and the visibility of it increasing, those sort of requests are going to become more common, and the requirement to respond to those and track those sort of requests are going to increase. So it does, I think, present some implications for the burden on individual health providers to respond to those type of requests, and whether they're coming in through an app that an individual has and having to verify that on their end presents, I think, additional challenges for the healthcare provider responding to those requests. Now, as far as having to tailor the information that you give back, I think that's a very slippery slope. I mean, it's very tricky. Like, if I got my health record right now, I probably wouldn't be able to make heads or tails of it for the most part. You know, to what extent you need to modify that to make it actually consumable and usable by the individual, I think that's an open question.
Yeah, I did want to make a point about to your question, Jeff, on like how a provider will decide to offer particular services for individual access, and if they offer access via the TEFCA network. So the TEFCA draft that we put out is very clear that it allows networks and others to choose the business model that they follow through participation in TEFCA. So you have a duty to respond to these individual access service requests, but you don't have a duty to offer those services. So you don't have to initiate the queries, but you do have to respond to them. So, and that's how TEFCA will work as a network. As a provider standalone outside of TEFCA, if you're a covered entity or business associate, well, you have to respond to a patient's right of access already, and there's no change to that we're pursuing through TEFCA. So there's a nuance there, I think, and that flexibility that we're trying to build into TEFCA for providers so that they don't have to offer TEFCA individual access.
Yeah, and I think in the conversations that we've had among the HIMSS membership, I think that is one point that especially I think some of our patient advocates have really honed in on. I think that we're still working on developing our comments to the Trusted Exchange Framework, and luckily we still have a couple weeks to do that. But I think that maybe one of the issues that we are looking at putting forward was maybe having a specific MiHIN that would be devoted specifically to initiating those individual access services. And that way a patient has the ability to send a query in without, there could be an instance where a patient doesn't work with a particular provider, doesn't work with a particular health system, and wants to initiate that sort of individual access service. And so how would they, what would be their entree into the broader TEFCA framework? So that's something that we're trying to nuance and trying to look at the moment. But I think I love the direction that ONC is going in terms of providing this and really trying to emphasize this, I think, with the second draft of TEFCA. So Nate and Jim, I will ask you another provocative question, and that is, when do we get to the point where too much information is being kind of transferred? Some critics have said that this could be a flood of information that would be transferred to the patient, and Jim, as you kind of alluded to, we can't make really heads or tails of all the information that's included in our electronic health information. So how would you respond to kind of critics that say this is going to be too much information to a patient that they're not going to know what to do with?
Yeah, that's a great question, and Nate alluded to it earlier as well. Does the patient really want all their electronic health records? I mean, there's pages and pages and pages, and a lot of it, every encounter is sometimes recorded. In a hospital, for example, every time a nurse comes by and checks on you on their rounds 4 or 5 times a day, that's recorded as in an electronic health record sometimes. So so it's going to be hard. How do you do that? And how do you comply with the obligation to give a consent? And what? So I guess it might come down to really the industry has to determine how can that patient request information. There's got to be a method by which they request certain types of information. And then another technical challenge, how does the person holding the data, all the healthcare data, parse through their records and come up with what that patient is requesting? So that's a lot to be worked out, and it's not going to be easy, I don't think.
Yeah, I agree. And Jeff, to your question, yes, probably there is a point where too much information is too much, but that's on the individual to make that determination for themselves as opposed to the providers. I mean, already you have, as soon as a patient has some sort of like symptom at home, what's the first thing you do? You Google it, right? Like, all right, WebMD, what's wrong? Oh, okay, it may be a rash, I may have cancer. All right, well, that doesn't help too much. So the additional information from your own health record, try as we might, or even if we want to withhold some of that in the patient's best interest, I don't think we can. There's just not an ability to do that under HIPAA. An individual can have access to that information, and there's very few situations in which you can't disclose that information to an individual, and a few exceptions there. But for the most part, individuals have a right to their information, and I think it means all of their information. And what we're going to have now is a more informed patient base, and I think providers are going to have to react accordingly to that.
Yeah, I want to just chime in
Sure.
to agree with Nate. I mean, it's common sense. People should have access to their own information. And the next step, though, is getting to what Jim was talking about, that there's a need for a app economy that will help filter that information, present that information in useful ways for patients. And so that's really what ONC is trying to facilitate, is a free market of competitive apps or other types of services that can take all of that information and then present it back to the patient in the most useful way. That's what APIs are about, but also TEFCA, which would enable apps to connect in to get all of that data. The challenges, though, associated with making sure that those apps are following the right privacy and security protections are things that we're concerned about and wanted to build into this particular provision. So, yeah, great points.
Yeah, and I think, John, that's a great point, too, in that, if you get blood work done right now, like an annual screening, you get the results back, you have X milligrams of whatever. Like, that information in a vacuum isn't that helpful. But then when it shows you, okay, the average range is this much, you're right in the middle, or you're a little high, or you're a little low, whatever, that becomes much more valuable information. And so hopefully these sort of service providers pop up that can interpret that information for you and generate a little bit more information for the consumer to make that or have that knowledge outside of a vacuum and with context.
Great. So we have a legal audience here, John. So I feel like I have to ask a couple legally focused questions in terms of just the requirements that ONC would place on QHIN and participant member agreements. Do you want to talk a little bit more about how that may work?
Sure. So I think it's important to recognize the different levels that would be created via the network that we're envisioning, and that the highest level is this interaction that occurs between ONC and the recognized coordinating entity. So that's going to be executed through a through a cooperative agreement that we have with this entity. We have a notice of funding opportunity right now available for entities to review and apply, and there are requirements built into that I'm not going to get into, but I encourage folks to review so that they understand what are the mechanisms that are built in there. The next step that moves down is the common agreement itself, which we would develop in coordination with this recognized coordinating entity and in coordination with the industry writ large. And that common agreement is only signed between the QHINs and the recognized coordinating entity itself. That will include those various governance provisions that are built into it so that they can monitor whether or not non-discrimination is actually being followed or not. Then from that QHIN down to their participants, they have their own agreements that would have to be updated in order to maintain congruity with the common agreement and flow down those provisions that have to flow down throughout the network. So they would then be imposing those requirements over their network and so on and so on. So it's a measure of accountability that does flow down throughout the network to ensure that privacy and security provisions are being followed, that technical aspects of the network are correct. Think of, is there, denial of service or any other types of data flows that look improper. I mean, networks already do these things today, monitoring audit logs, et cetera. Those things would be built in so that we could have that accountability throughout the network.
And I think it's important to point out too that, you know, we're talking about the common agreement, and as John says, that's the agreement between the RCE and the QHINs. But as part of that agreement, there's a requirement to push down specific provisions to the participants and the participating members. So even though you have an established agreement already with a HIE, or you are an HIE and you have it with a larger entity, there is going to be some contractual work that happens because of that that agreement between the RCE and the QHIN says you have to include in your provisions with your participants the following requirements, and then kind of list them out. So look for that in coming attractions.
Right. Most of us remember when we all of a sudden required to have a BAA agreement between covered entities and service providers, other groups. So this is going to be like that on steroids. So a lot of work.
Yeah, so John, I'm curious whether there's going to be any discussion as far as who's going to have liability for data breaches and limits on liability.
So these are things that will be built into the additional required terms and conditions that flow throughout. There are well-established mechanisms for liability already in network agreements, and so that was an area that we didn't see as needing us to establish some sort of minimum bar, where we didn't feel there was a lot of disagreement among folks, and so if you do have thoughts though on that, you know, we encourage you to submit comments and build those in.
Yeah, there's a lot of contracting between players in the healthcare industry still being done on paper, inked paper. So I think, and I encourage this for my clients, the more you can put terms and conditions up online and refer to them by a URL, that helps in the contracting process. So say you're an electronic health records vendor, a lot of the paper contracts are driven a lot by the providers. But if the common agreement can actually say, hey, it's okay to implement these contracts by putting them online and referring to them from a URL, that can allow the community to get more comfortable with that, and that will allow the updating of contracts to be a lot more efficient. So that's something that I would encourage.
Yeah, we're really all about open and transparent processes, and that's going to be part of the recognized coordinating entity's work, is to convene people to be able to talk through these things and hash out really where those differences are. I fully agree with that.
So why don't we take a pause with our questions up here? Does anyone in the audience have any questions that they would like to pose to the panel? Chair, sir, do you want to stand up? I think we have a microphone coming right there.
Thank you, Tom Simmer. I chair the HIT Commission, and which is the Health Information Technology Commission for Michigan. And we do a lot of talking about consent forms and consent standards. And now that interstate sharing of information seems to be on the horizon, what recommendations would you give us for making our consent process in Michigan the most consistent, easy, usable approach for purposes of not having to have all of our EMRs follow a different standard, or our HIEs follow a different standard, or when we get requests from out of state having a different standard? How can we most approach a common standard? Because I'm not sure that one exists. Any comments?
Yeah, let me jump in first on
okay.
that. So to explain the approach that we've taken with TEFCA, which is to say that applicable law applies. So what that means is if you're a provider dealing with a patient and want to request data via the network, if you're an opt-in state, you will have to obtain and maintain consent as that state law requires. You don't have to then follow all 50 states. The idea is where the provider and the patient reside, they follow the laws that apply to them. So we wanted to respect state law with the approach that we took. We didn't have the authority to preempt state law with what we're doing. We do see a lot of we have a lot of experience with different states. I mean, I've worked with states for 8 years and worked on different consent policies, et cetera, but that's not part of TEFCA. That's sort of part of our coordination activities, and we're happy to put you in touch with other folks or resources that have experience across other states. We've done reports on this and can share that type of information with you, but for TEFCA itself, that's not something that we're looking to resolve.
So, Jim, Nate, any comments on that?
Yeah, from I agree. That's the common approach right now. There's no standard. For the Commonwealth Health Alliance, for example, I think of the Commonwealth Health Alliance as it's a hub and spoke situation. The alliance is in the middle, and our members are out on the spokes, and then their users and providers are at the end of those spokes, and they're in all 50 states. So how do you deal with consent? We did exactly what was just described. We say, hey, you have to comply with all applicable laws, and you push it out to the we have minimum terms that we require our members to pass on to, say, providers and to end users, and we have policies around security policy and compliance. That's how it's done right now. So I don't know how else you could do it without a mandate from the federal government requiring a particular type of consent by everybody, at the end user level. But right now it's pushed out. You have to comply. You require them to be compliant. There's liability if they're not compliant, with indemnification provisions associated with that non-compliance. And then it's up to the people who have been getting consents all along to comply with their local law. But that's tough. What happens with data that comes from one state to another, and you have different consent requirements and obligations? Data's flowing back and forth through a network. At some point, those inconsistencies need to be reconciled.
Sure.
Hi, can you hear me? Yes.
Yeah.
Erin Mobley, Policy Planning and Legislative Services with the state of Michigan. My question is regarding information blocking, but not in the traditional sense. My background before being with the state was in translational medicine and oncology research. And in the research world, we regularly ran into issues where we could not get biospecimens or tissue of patients from other hospitals. And so not necessarily data, but definitely something that I believe belongs to the patient. And I just wondered if the ONC or anyone else looked into that, is aware of that, if there's any work being done to kind of help that situation move forward.
Yeah, this is a great point to make a plug for tomorrow's presentation from Elise on ONC's policy activities broadly. I can respond just from the scope of information blocking that it applies to electronic health information, so practices that interfere with, prevent, or materially discourage the access and exchange or use of electronic health information is what the statute says. So that sounds like it's outside the scope of what CURES calls for.
Sure. Sarah?
Thanks. Great discussion. Tim Pletcher, Michigan Health Information Network. Been getting a lot of questions about patient access, a lot of concerns about patients giving consent, having Cambridge Technologies and sort of even foreign governments sort of playing this out against us, so to speak. And in some of those discussions, one of the things that's come up is anyone concerned about the unintended consequence of folks perhaps acting in truly nefarious or acting in subtly nefarious ways, and essentially using artificial intelligence to reverse engineer the intellectual property that is embedded in a lot of our institutions. And essentially, is there any provision even being considered that protects the intellectual property in aggregate of when patient access information is used to sort of reverse engineer trade secrets, intellectual property for the organizations that an individual patient wouldn't have enough, but thousands of individual patients getting access to that information and giving it to somebody would.
So I'll try and take that. Thanks, Tim. Couple different points to that. First on TEFCA, which is that individual access services, if you're requesting the data for that use case, you can't reuse that data for other use cases. So or for other exchange purposes. So that's a protection that's built in there that sounds like it would implicate part of what you're talking about. I think one of the things that keeps me up at night is, are we building something that's really secure and that will ensure that the data is protected and that nefarious things won't happen like what you're talking about. And we've built strong protections of privacy security into the policies that we've proposed. And those include things like requiring identity proofing at the IAL2 level for anyone who accesses the network. If you're an app, you have to actually do that. A lot of apps don't do that. You just sign up online. So that's an additional cost. There's a certain bar that's going to be met there. Also, that entity, to Jeff's point earlier, will be held accountable to actually doing that by whoever they're connecting into via the network. So those are just some of the thoughts that we've put in there. I do want to say, on the points about artificial intelligence or other ideas of how this may or may not work, please comment on that. We really would love to hear about it. We have experts on cybersecurity and legal policies, data sharing policies, et cetera, at ONC, but we don't know everything. And part of the reason we're here is to learn from you all and to experience what it is for the challenges that you guys are facing. So if you can bring that knowledge in your comments, we would really appreciate it.
Yeah, and with regards to IP, I think two buckets I think are most important to actors in the industry. One is data. There's IP and data, really important data rights. And then there's intellectual property and software and solutions. So part of TEFCA is requiring people that have data to give access to that data through APIs. Proper use of APIs is that not only is it well documented and easy for somebody to interact with it, but there's also security built into those APIs whereby somebody accessing data through the API has limited access to behind the firewall. So you have an API, you might have data going back and forth, but there's a firewall and it's behind that firewall of that company, that healthcare provider, that electronic health record vendor, whatever it is. That's where their IP and might have algorithms, they might have their software, where all their solutions and their applications reside. It wouldn't hopefully not be accessed through that API that's publicly facing. So proper security and API structure and development is really important. But the industry is well along in that category, so I'm not too concerned about that. But data and the analytics of data and then commercializing that is huge right now. So what we're requiring those people who are focused on commercializing data now to share that data, that's going to be interesting. It might be an issue if you could accumulate all the data at the endpoints and put it back together and try to figure out how to reverse engineer what's going on with an algorithm. I mean, that's kind of far-fetched, but other than that, I don't know if there's really that much of a risk.
And I would add that what we're trying to do in healthcare is not unlike what has happened in other industries. Specifically, I'm thinking of financial industry, right? So right now, what we're trying to accomplish in healthcare, I think the financial industry is kind of further down the road than we are, that it's not that difficult these days for you to get an app of some sort that goes out and grabs all of your financial information from a bunch of different spots with a little bit of effort on your part and then accumulates that for you and makes it relatively easy for you to access that and see real-time updates to that information. And there may be lessons that can be learned in those industries, and I would encourage anybody who's in the security space to reach out to their counterparts in other industries to see what's worked for them, what have some of the lessons learned been for them there, and not have to reinvent the wheel at every step of the process.
So, John, do you want to talk a little bit about QHINs and the responsibilities of QHINs in terms of oversight? Will QHINs have to take on a more of an oversight role in terms of the participants meeting certain requirements?
Yeah, exactly. That's this flowing down of accountability that we're talking about. And I think that a point that I wanted to get into that I haven't described yet is this additional process that we built into the second draft of the TEFCA for identifying and designating who QHINs are. This is a process that will involve QHINs applying and through an application process describing that they have a reasonable approach to complying with applicable law, to applying those various provisions that you're talking about, Jeff. And then they enter a cohort and go through a provisional QHIN status where the RCE will monitor them to make sure that they are in compliance. And once they've completed that, then they would get the stamp of designation as a QHIN. So there's provisional QHIN and then becoming a QHIN. So that process was built in to help with ensuring that those provisions are all complied with, but there are other reasons for doing this too. We didn't want any QHIN to have a first mover advantage, so to speak, like you shoddily put your stuff together and then get out there and in order to capture the market. Instead, you would be able to go through a cohort where they all would be able to go live together at the end. So just a few points on that question.
And John, I've got a follow-up question for you. In version 1, there was some discussion about how many QHINs we were thinking of having, and I think the discussion at the time was a few dozen, certainly not one per state. It sounded like there was going to be far fewer than one per state at any rate. Is that still the thinking at ONC, that there's going to be a limited number of QHINs in this context?
And so we are not saying a specific number, and that's because we think there's a range of number of QHINs that could be possible. There are a good number of QHINs that could qualify for what is required of them to become a QHIN. We get a iteration or a version of this question quite often, and a lot of times folks are just saying, they just jump right to thinking, I want to be a QHIN because they're at the top, right? And our response is, really think about what it is that being a QHIN requires. It requires nationwide lookup of data, being able to coordinate that on a nationwide basis. And that's not in the business plans for a lot of HIEs. Instead, they provide services for their own constituency that serves their needs. And so we want to make sure that folks understand that we've built TEFCA in order to allow for stakeholders to connect in at the level that is appropriate for them.
Great. So to change gears a little bit.
We do have one
I
question.
think Helen
here
had a
real quick.
question.
Oh, okay.
Hi, Helen Hill from MiHIN board. I have a question about layers of complexity and cost and how you'll manage that, how you'll report it and make sure that you don't cripple the existing industry where margins are very, very thin. Some of this sounds very necessary in this model, but I'm wondering how you plan to manage that, and also what kind of oversight will you apply to the RCE, which will have pretty broad powers to determine who does what in the industry going forward?
Yeah, a couple points on that. As far as costs, well, right now our lack of interoperability is causing tremendous costs within the industry. And part of what TEFCA is looking to do is reduce that and save money for legal, technical costs. There are a lot of different provisions related to fees and costs that go into our thinking on TEFCA, and there are specific fee reporting requirements for QHINs up to the RCE that are built in to ensure that things like non-discrimination among competitors is occurring, so that they are not discriminating. That flowing of data up to the QHINs, or sorry, to the RCE is really critical to make sure that this works. And to your other question, ONC will be entering into a cooperative agreement with an RCE where we will be continuously involved in their work. A cooperative agreement is a different type of mechanism for government work. There's grants, there's contracts, and cooperative agreements. And cooperative agreements allow for, like what it says, cooperation, close coordination. So we're going to be working very closely with the RC to ensure that they are able to be successful and that they do all of the things that they will be agreeing to do, such as ensuring that independence that we talked about, the neutrality that commenters expressed very clearly to us is so important for those same reasons, Helen, that you mentioned.
So, Nate, not to put you on the spot,
But I'm
but as a
gonna put you on the spot.
Michigander, how do you think the infrastructure within Michigan plays into the TEFCA framework? You know, how well positioned is Michigan to participate broadly in kind of TEFCA?
Yeah, I think we're in pretty good shape, actually. I think there is a general, kind of the Midwestern attitude of like, I think that trickles over into industry as well, is that we generally want to play nicely with each other and recognizing that we do have entities that are all competitors in many ways, but that are or have been willing to take those first steps, sometimes tentatively, to share data with their potential competitors or just share data generally. So I think we are well positioned. We have a fairly robust health information exchange structure within the state, so I think that goes a long way, and I know that other states have looked to Michigan as a model for what they are trying to accomplish in their state. So while there are going to be some growing pains to incorporate TEFCA into current legal agreements, not only between for whoever the MiHIN for that would cover this area would be, but then you and your participant members, there are going to be those pains, but I think ultimately that we can get through that probably with a little bit less pain than other states. I think Jim brought up a good point as far as the electronification of our agreements, that there is, I have seen that as well, that there is some hesitance, and I understand where it comes from, to electronically agree to certain contracts, and that's probably the next hurdle to get over, that to the extent we can move to that sort of model, I think it will make the process easier here.
Yeah. Jim, any thoughts on that?
No, I agree. I think that's going to be a challenge, and pushing agreements to the cloud sometimes that helps, because those agreements can be updated and can be updated when the law changes. So that's one important thing. I think another issue or challenge that's going to need to be worked out is liability amongst all the players. Right now, there's a range, every contract you look at between players in the healthcare industry, they have to agree on limitation of liability. Who's liable for a breach? Who indemnifies whom, right? So how do you do that when you have the common agreement, I don't know, John, if you have that worked out yet, but is that something that would be imposed on all layers? I don't know if I saw that in my review.
Yeah, that's what we were talking about a second ago, that is currently happening, and we're leaving to the additional required terms and conditions, so that's going to be worked out by the RCE. We'd love to hear comments on that. So I'm hearing a couple. Please submit those, either as part of your Commonwealth comments or others. But Jeff, I did want to talk to your question about Michigan and how they're positioned. So one of the things about TEFCA that's really exciting is that local solutions are going to be enabled by a national baseline created by TEFCA, whether that be provider directory services, identity management services, or other types of services that enable value-based payment. And that's something that MiHIN is involved in, whether it's the common key service or the active care relationship service that MiHIN offers. I'm really curious and eager to work with folks this week and learn more about that interaction there, because TEFCA doesn't do everything. As I mentioned in my presentation, we're not looking to create one network that solves everything. Instead, we're doing network-to-network connectivity, enabling local baseline or local solutions that can create better value for patients within their particular context. So just want to mention those couple things. Really excited to learn about those from Michigan this week.
The other part I want to add, obviously, and I think Jim is right on, that the limit on liability for data breaches is usually the long pole in the tent when working through any sort of data sharing agreement. And in an effort to capitalize on sort of the Play Nice Club that we have in Michigan, I would encourage you to reach out to your fellow healthcare providers or entities or whatever kind of the subspace that you work in, as far as making sure that security, you have like an understanding of security protections. So data security does not provide a competitive advantage to most organizations. In other words, your patients aren't choosing you as a healthcare provider because you have the best data security in place. So there is not usually an advantage to hoarding security information to yourself, because your patients, your customers, your clients aren't choosing you because of your security. So to the extent that you can share information, security, procedures or risks or threats that you've seen, and can raise the level of security awareness generally among all the healthcare industry within Michigan, it's to everybody's advantage. Because as we've seen, hackers are very interested in targeting specific industries, and once they've recognized something that's exploitable in one industry, they'll go after various entities within that industry because they assume it rightly that it is a similar security vulnerability within that organization. So ransomware within hospitals has been really hot the last few years as an example. But being able to share that information and raising the tide of security awareness among what would otherwise be your competitors is going to be to everybody's advantage. Yeah, there's a question out here. Just belt it out, I guess.
Statement is what's your question? So actually in Michigan, we do have the Michigan Healthcare Cybersecurity Council.
Yep, thank you.
Which is comprised of pretty much all of the large facilities within the state. I surrounded up as part of looking at positions for the Michigan State Medical Society. There is a new HSOC in the state of Michigan, located in Plymouth, that a lot of the facilities are taking part in. So what he's talking about is happening. A lot of people just don't realize it's happening because it is kind of quiet, but facilities are sharing when there are any alerts going out across, I get alerts, the facilities get alerts. There have been many instances where personnel from one facility has gone out at another with the information that they have and knowledge and expertise. So a lot of that is happening in the programs.
Thank you.
Yeah, and there are national activities as well to help with coordination. HHS does some of that, and there's other federal ones too that would love to help connect people to if they are interested.
Yeah, sure, yep.
Sure. So I have a couple questions. The first one is that when the first draft of TEFCA was released, we heard a lot about the fact that it would be a completely voluntary framework, so participation would be voluntary. Is that still true in the second draft? And if so, why did the ONC choose to make it voluntary? Because we do know that the 21st Century Cures Act mandated the ONC to kind of develop this trusted exchange framework. So is there any fear that when we call it voluntary that there might be participants that just say, well, I don't want to connect to any network because it's voluntary?
Yeah, thank you. And yeah, it's important to understand exactly what Congress called for in the Cures Act. And it is clear that Trusted Exchange Framework Common Agreement should be voluntary. However, there are provisions in the 4003 section of Cures that say that HHS can require participation through other programs. So the two examples that I'll mention are related to the ONC proposed rule. And the first of those, and Elise will talk more about these tomorrow, but the condition of certification for electronic health record vendors, that we have a request for information in the rule about whether participation in TEFCA should be required as a condition of certification for those developers. So it's a request for information, it's not a request for comment, so we would have a subsequent rule that would implement this. The other is as a potential exception for information blocking. So would complying with the Trusted Exchange Framework and Common Agreement qualify as an exception to information blocking? Again, a request for information under there too. So the point I want to conclude though with is Congress was very clear that they want to see TEFCA succeed, and to do so, we are really eager to have early implementers to come. We think that there is a value proposition to be had for stakeholders across the board, whether it's patient providers that could get better access to data for their patients, payers to be able to execute their internal functions, et cetera.
Nate, Jim, any comments?
No additional comments.
Right. Yeah, so I'll just chime in with the HIMSS perspective for just a moment, moderator's prerogative. But I think that, what really speaks to me is one of the first slides that John put up there around the proliferation of agreements that are required to exchange information across, nationwide exchange and enable a nationwide exchange. So I think keeping that in mind with the challenges that currently exists, and TEFCA, I think, is out there as a solution to try to address all of that. And I think ONC has done a great job putting together a workable solution for the entire community. There are still a couple weeks to comment on the TEFCA. I would say that there are approximately 13 hours left to comment on the ONC rule that John just mentioned as well. So I think that those are two important pieces that I think that they really want to hear from broadly from the community about.
That's right.
So I wanted to, Nicholson Price from the University of Michigan Law School. I wanted to ask whether or not there's a possibility of opting out of TEFCA in kind of the opposite direction. So you mentioned that patients can say, we don't want our data shared in any way through this. I'm wondering if there's a possibility for kind of a virtual all of us, or patients being willing to share their data more for research purposes, which is what I'll be talking about in some of the next panels. So you said, I think earlier, John, that if there were an individual access app, then the entity that designed that couldn't use it for other purposes. Would it be a possibility for something to say, here's an app, download your data and share it with a community of similar patients for research purposes, and this is a way to kind of bring information out of the HIPAA TEFCA framework, which can sometimes be challenging for aggregating information? Or is it the case that once it's kind of in there, those protections and those rules are always there for kind of whoever?
Yeah, it's a great question. And we did limit the exchange purposes to not include research purposes, partly because of various challenges that are associated with this. And would really like to hear folks' comments on how one could go in that direction. I want to mention that we have a phased approach to TEFCA, where we are looking to have a network that expands over time to encompass additional use cases. So would love to hear about folks who are curious and moving in that direction, and happy to include you in discussions future. Another question.
Sure. Question.
Danny Zajac from Olympia Medical. I was wondering if you guys could touch on what accountability means, and is it created equal? So Jim mentioned, we have a lot of challenges, especially technical challenges that we have to address. And we have a market leader, health record leader for hospitals that is written in a 1980s language that is essentially non-queryable. It varies from system to system. So at what level are we going to hold these vendors accountable if it compromises the marketplace?
Anyone want to take that question?
Well, one of the first things I said was I'm a fan of TEFCA, and that's because I think it's moving in the direction to actually open up some of those otherwise closed environments, whether it's data blocking or actually just continuing on with the same old data-based structures that are just in format and file formats that are non-compatible with other vendors. So I think that the pressure from TEFCA and the direction that the government is bringing, ONC is going to bring those vendors kicking and screaming, I think, to be more open. That's my hope.
Yeah, I can just mention two things about accountability. So we're talking about TEFCA, and I've talked about the different mechanisms that will allow for accountability to flow throughout network protection. Those are all incredibly important to ensure that this network functions properly. The information blocking side also will impose accountability on providers, developers, networks, and exchanges. So for those developers, networks, and exchanges, if they violate information blocking, for each instance, they would be liable for $1 million penalty per instance. So That's accountability, if you ask me. For providers, that we have a request for comment on what the appropriate disincentives are. Again, come to the presentation tomorrow from Elise to hear more about information blocking.
So any final questions from the audience? Oh,
This is Shreya Patel from MiHIN. I have one more question. So we have a lot of advocates for TEFCA. I also am an advocate for TEFCA, but I was wondering what are some of the key criticisms that you've heard from the industry as a response for this most recent draft that has been released? And kind of going off of that question, what is your response to some of the criticisms that you're hearing?
So we've been hearing a lot of support for TEFCA and have been having conversations not too different from this, hearing from folks that are saying, oh, I'm a fan, or thank you for responding to our comments. We do want to hear more, and we want to make sure we get this right, and that's why we did a second draft. So we're asking folks to submit their comments, and then we're going to analyze those and put all of our brains together to try and put those put together a position for what the next step is. And that next step is going to be working through a recognized coordinating entity who also will be working with industry to make sure that we get this right.
so Jim, Nate, any concluding comments before we? Oh,
I just have one quick question. How long, we started sort of the MiHIN stuff in what, 2008, 2010-ish, somewhere in there. How long before you think the RCE is really going to have sort of working infrastructure happening?
I'm glad you brought up the question of how long have we been waiting, because we have been waiting a very long time, and Congress recognized this, and that's why they created very specific direction around what we should be doing. And we've been working diligently to try and put this all together. The timeline that I shared shows 2020 is when we would be able to get out the first version of the Common Agreement. We say that's version 1 for production, and that is because there will be future versions. We're not saying it's the final Common Agreement. This is going to be an ongoing thing, and this is something that we're really excited about. We do think it's going to take a lot of work, but there is a timeline. And so, again, review the MRTCs, the timelines we put into the NOFO, et cetera, to get a full understanding of each step along the way. We've gotten granular on this, and we are very serious about making sure that this is successful, and so is the administration. So.
well, why don't we conclude on that positive note? Thanks, John.
Thank you.
Thanks very much for a great panel discussion.
Thank you.
So I think we move into a break now. Thanks very much for the opportunity to speak today.